Thank you to our audience for returning to the 24th Annual George Mason Law Review Antitrust Symposium. My name is Bruce Kobayashi, and I'm a professor here at Antonin Scalia Law School. I have the pleasure of serving as the moderator for the first panel this afternoon. This is actually day 3 of this year's virtual program. We've already seen 4 excellent sessions, and today we will have 2 more. Later this afternoon, we'll hear about antitrust and collegiate athletics. But first, we will discuss in this panel the future of FTC remedies. On January 13th of this year, the Supreme Court heard oral arguments in AMG Capital Management versus the FTC. The court will decide whether the FTC has the authority to seek monetary relief under Section 13B of the FTC Act. And we have an outstanding panel to discuss the issue presented in this case and the future of FTC remedies more generally. While the AMG and CBC cases involve monetary remedies in a consumer protection cases, the current set of challenges to the Commission's use of 13B to obtain monetary relief started actually on the competition side with 2 cases in the Third Circuit, Shire Biopharma and AbbVie. So we will begin there with our panel with Debbie Feinstein, who heads the Arnold and Porter's Global Antitrust Group and served as the director of the Bureau of Competition at the FTC from 2013 to 2017. We will then hear from Seth Waxman, co-chair of the Appellate and Supreme Court Litigation Practice at WilmerHale. He was also the Solicitor General from 1997 to 2001, and he argued the case for the appellants in the AbbVie case in the Third Circuit. We'll then move to the CP side and hear from David Vladeck, professor of law at Georgetown University Law Center. David was also the director of the Bureau of Consumer Protection at the FTC from 2009 to 2013. David was the counsel of record for an amicus brief of former FTC officials in support of respondent in AMG. Following David, we'll hear from my Scalia Law colleague, Tim Muris. Tim is also a senior counsel at Sidley Austin, and he is, except for BE director and general counsel, has held every high-level position at the FTC, including serving as the chair of the FTC from 2000 to 2004. To say everything I know about 13B and monetary remedies, I learned from Tim and Howard Beale's excellent ALJ piece. And Tim's just reprised many of those themes in a recent piece in the Antitrust Source with Mundell and Beals. To close, we'll hear from Sam Levine. Sam is currently an attorney advisor for Commissioner Rohit Chopra, and he and Commissioner Chopra have a recent article on the use of cease and desist orders and penalty offense authority under 5M1B that they argue will enable the FTC to directly impose monetary remedies no matter what happens. All right, well, it is now my job to get out of the way and turn it over to Debbie.
Well, great. Thanks very much, Bruce. And it's a pleasure to be here virtually. I very much enjoyed this conference and interacting, especially with the students. So I miss being there in person and hope we'll be there together again next year. So I just wanted to provide a little background on 13B to sort of set the stage, focused on the competition side. It's used more often on the consumer protection side, but since I'm on the competition side, I'll talk a little bit about that first. So, you know, the idea that disgorgement is necessary goes back to, Grinnell, where the Supreme Court noted that adequate relief in a monopolization case shouldn't just end the monopoly, but, quote, should deprive the defendants of any of the benefits of the illegal conduct. And the commission in a competition case has used it, about a dozen times or so, starting in 1998 against Mylan. And the FTC's views on this have changed over the years. First it just started using it, and then it was necessary to they decided to adopt the 2003 policy statement, which I'll talk about in a minute. And then they withdrew the policy statement a couple of years before I got to the commission amid some controversy. And so the controversy is whether or not it's a good idea or not. And, at some level you think, well, why is it ever a bad idea not to impose monetary penalties? If it's deterrent, why isn't that useful. And the reason is because there's a big group of folks who also think it's really important that the commission's job is not to go get money for the Treasury, because sometimes it can get it to consumers, sometimes it just goes to the Treasury, but to basically help develop the law, that it was meant to be a specialized agency and that there are others, the states, private plaintiffs, who can then bring suits to follow on, and that if you are going to federal court instead of the FTC administrative proceeding, that you lose something about what makes the commission special and what enables it to help develop the law. So critics, and one of the commissioners who has raised that issue is Maureen Olhausen, who has consistently argued that the incentive to seek monetary remedies may cause the FTC to neglect its special mission to develop the antitrust laws through the administrative process. So even in times when she's, perhaps agreed with the underlying substance of a case, she's resisted the notion that the commission should go into federal court, preferring instead to bring those kinds of cases through the administrative proceeding. Critics also point to the uncertainty it places on business, especially in cases where the commissioners disagree as to whether or not a violation has even taken place, and say, look, if you're going to do disgorgement, it should be left for that very special set of antitrust cases where everyone agrees that it's a clear-cut violation. And since there aren't so many of those cases, there are those at the commission who have said, wait, we can't just do that. We need to do it in cases where we think the conduct's been particularly egregious. So that's been sort of the debate over the years. The 2003 policy statement laid out 3 criteria guiding the commission's discretion. Although they said, you don't have to have all 3 necessarily if it's clear on one. First, is the underlying violation clear? That issue I mentioned a minute ago. Does there exist a reasonable basis for calculating the amount of the payment? And does the remedy make sense in light of the context of other remedies available, including private suits? And in 2012, that was withdrawn. So what's happened? So most of the fact patterns where there's been disgorgement on the antitrust side have been monopoly cases. And all of them have been within the healthcare sector. There have been reverse patent settlement cases, exclusive dealing acquisitions, sham petitioning. Those have been the sorts of cases that have done it. And then after the policy statement has been withdrawn, there have been more usage of it, but the numbers are so small, it's hard to make too much of it. It was invoked 4 times prior to 2012, between 1998 and 2012, and 7 times since. But a good number of those have been reverse patent settlement cases, which, they weren't as prevalent in the earlier years. And so it's a little hard to raise too much, to use those numbers to tell you too much about whether it's being used a lot more or a lot less. But that's sort of the background against which the current debate about the use of 13B is taking place, because while the context of the decision that others are going to talk about comes in a consumer protection case, the ramifications on the competition side are significant as well.
All right, thanks, Debbie. Seth.
Hi, everybody, and thanks to the organizers of the symposium for including me in this. I feel like I'm really the innocent abroad, since I'm surrounded by people with long experience at and expertise in the FTC, and I'm just a country lawyer who happened to argue a case or 2 against the FTC. I will say that during the period that I was Solicitor General, I had a terrifically cooperative relationship with the folks at the FTC, and I think it's fair to say we were aligned on virtually every issue that came up that concerned the FTC. But that has not always been the case between the Department of Justice and the FTC, and we'll probably get into this later in the program, but there's some indication over the last year, in light of the filings, that on the one hand, the Solicitor General has made, and on the other hand, the FTC has made, with respect to the availability of disgorgement, restitution, and other non-injunctive remedies under 13B. As Debbie was saying, the 13B, the controversy over the Commission's authority to recover retrospective monetary relief in the form of disgorgement or restitution, which had sort of been taken for granted by the lower federal courts for a long time, started, I would say, coming off the rails as the result of a couple of cases in the Third Circuit, as Debbie mentioned. In the first one, the FTC brought an action against a company called Shiro Virapharma. And Shire basically said, well, look, the action that you're complaining about and the basis for invoking 13B has long since ceased. We're not engaged in that kind of activity. The FTC said, well, yeah, but you could be a repeat player. You know, you've shown, in our eyes, you've shown yourself to be incorrigible and it could happen again. And the Third Circuit basically said, well, look, 13B says that the commission can invoke this particular tool whenever it has reason to believe that any person, partnership, or corporation is violating or is about to violate any provision of law enforced by the FTC. And the Third Circuit dismissed the case on the grounds that, you know, whether the FTC was or wasn't right that Shire Virapharma might ever violate the act again in the future, it wasn't in the context of violating it, it wasn't about to violate it, and therefore it was not going to allow the suit to proceed. The case against AbbVie was a sort of classic reverse payments sham litigation case. AbbVie was the brand name manufacturer of a particularly commercially successful drug. It is under Hatch-Waxman. Two generics decided to enter the market. They filed the requisite notice, and as Hatch-Waxman contemplates, because AbbVie, they claimed that they could enter because AbbVie's patents were invalid. AbbVie thought its patents were valid. It filed a lawsuit against them. The suits were ultimately settled. And a couple of years later, the FTC came in and said, aha, that was sham litigation. And the only way you settled these cases was to make the kind of reverse payments that was at issue in the activist case. AbbVie defended, and the issues in the case largely related not to this authority for disgorgement under the FTC, but rather the sham litigation exception and a whole host of technical patent issues involving the doctrine of prosecution history estoppel and the so-called tangentiality exception to prosecution history estoppel. In fact, the case was so overwhelmingly laden with patent law issues that the very first question that I got when I was up on appeal, and I think actually it was the FTC's lawyer, Matt Hoffman, got, because he was the principal appellant, was, why is this case even here? We're not the Federal Circuit. Are you sure that we have jurisdiction? I then got up and assured the court that I agreed with Mr. Hoffman that the court did have jurisdiction. The three judges were so skeptical, or at least intimidated by the patent law issues, that they then issued an order after the argument directing us to file supplemental briefs on why on earth they were going to have to decide these technical patent issues. But in a nutshell, so the FTC sued, challenging the reverse payments and the alleged sham litigation. District Court dismissed the reverse payments claims, found that AbbVie had engaged in sham litigation, imposed a $448 million disgorgement order under Section 13, but denied the commission's request for injunctive relief because it found the behavior in question had ceased years previously, and therefore there was no warrant for an injunction. And so there were cross appeals. The FTC cross appealed on the issue of reverse payments, and we cross appealed on the finding of sham litigation and on the issuance of this disgorgement order, arguing that Number one, the FTC didn't have authority, a court didn't have authority to order disgorgement under 13B because 13B is limited by its terms to seeking an injunction, a temporary restraining order or preliminary or permanent injunction, and doesn't mention retrospective relief. And in any event, following Shiro Vira Pharma, since the district court was correct in finding that there was no basis whatsoever to issue an injunction, and since the FTC's argument is that the ability to obtain other kinds of, quote, equitable monetary relief were subsidiary to the traditional right of an equity court imposing injunctive relief, to issue corresponding monetary relief if there was no jurisdictional basis and no merits basis to impose the remedy of injunction. Obviously, there wasn't the ability to impose a remedy of disgorgement, even if disgorgement is contemplated by Section 13B. While the case was being briefed, we were, at least on the AbbVie side, particularly tickled and delighted when the Seventh Circuit decided to weigh in a case called Credit Bureau Agency and reversed its prior ruling that the FTC did have authority under 13B to seek disgorgement as a remedy, and held that in fact it did not. And so we were able to bring that to the attention to the Third Circuit as well. The oral argument in the case was a year ago. It went very long. I don't remember all that much about it, except that the court seemed to have very few questions for me about the disgorgement issue in 13B. They did seem to have quite a few questions for my friend on the other side, Matt Hoffman, representing the commission. And in the end, and I guess this was the end of September of last year, the Third Circuit ruled. It held that the district court was wrong to dismiss the reverse payments claim, and it remanded for further proceedings. It held that the district court was wrong in finding that there was sham litigation against one of the generics, Teva, but right in finding that there was sham litigation against the other generic, Perrigo. Held that the court was right in finding that that AbbVie had market power, and that the court was absolutely right in finding that there was no basis for an injunction, and that the court was absolutely wrong in ordering $448 million of disgorgement because Section 13 of the FTC Act said the Third Circuit did not authorize the commission to seek or a court to impose a monetary remedy. It was limited to injunctive relief alone by its terms. Under the current relaxed COVID-era Supreme Court deadlines for petitioning, the Supreme Court for certiorari, the period for petitioning will not run, I think, until the end of March. And neither the commission nor AbbVie have yet filed a cert petition in the case. Both seemed sort of equally aggrieved by the result in the Third Circuit. And so it remains to be seen whether there will be further litigation. I think that amply uses my 10 minutes, even if it wasn't particularly helpful.
All right. Well, you'll get some time on the back end. All right. So we're going to move from the competition side over to David Vladeck and talk about CP side.
Well, first of all, thank you so much for inviting me today. Let me just start out with first principles. This is all Tim Muris, and this was Tim Muris's brainchild. When the FTC changed the helm in 1980, 1981, there's a fairly dramatic shift in the FTC's emphasis. Prior to then, and anyone who was around during the late 1970s knows about the FTC lines of business litigation, which dominated the DC circuit. And the FTC was focused much more on large market practices. In 1981, when Tim and new chairman came in, there was a real focus on fighting fraud. And let me just read you what Tim talked about in a hearing in 2010. He says, we created the FTC's modern anti-fraud program in 1981 when I was director of the Bureau of Consumer Protection. The development of a vibrant anti-fraud program at the FTC is a major success story. Fortunately, the legal tools for such a program already existed in Section 13B to allow the Commission to sue in federal court and to obtain strong preliminary and permanent injunctive relief. He then adds, almost from the inception of the 13B program, the Commission has not only halted fraudulent schemes, but has also pursued consumer redress and other potent equitable remedies to benefit consumers. Very early in the Section 13B consumer protection cases, the Commission obtained, as ancillary to the issuance of a permanent injunction, provisional remedies such as a freeze of assets, expedited discovery and accounting, and the appointment of a receiver on the ground that these remedies would ensure the effectiveness of any final injunction order. And so the program that Tim initiated in 1981 has served the American consumer quite well. The FTC has aggressively gone after frauds in the marketplace. It has used its authority under 13B not only to get injunctive relief to stop the harm that consumers are suffering, but also to restore them best as possible to the status quo ante. Now, once this program was launched, it was reviewed by 8 circuits. And Seth is not exactly right. This argument was made in every circuit. The argument that won the day in Credit Bureau more recently. So these were hard-fought cases, but not a single judge in any of the 8 circuits disagreed with Tim's theory, which is that Section 13B empowers the Commission, empowers courts to order this kind of redress. Now, a couple of things about Section 13B. It was passed in 1973, but it was not really used as a tool by the Commission until Tim got there. Why? Because the Commission was not, prior to 1981, really focused on these kinds of fraud cases. But when it started to really sort of ramp up the anti-fraud actions that the Commission brought, 13B was there. So this case, this issue was litigated aggressively in 8 circuits. And the 8 circuits unanimously found that the 13B argument that the Commission was making was sound. These were not simply do-over cases by other circuits. The issue was litigated in each one. Now, there has been pushback more recently. Why? I think there are reasons that haven't been surfaced yet. Since the mid-1980s, the Supreme Court has been on somewhat of a tear to restrict equitable remedies. And one of the arguments that's been made and was featured very prominently in the Seventh Circuit's opinion in the Credit Bureau case was that the foundational rulings back in the 80s had been undermined by more recent Supreme Court cases dealing with the scope of equitable remedies. And so the real issue here is whether the background law that existed in 1973 when Section 13B was enacted by Congress is still sound. The intellectual foundation, and this again I credit Tim and his colleagues at the time, the intellectual foundation for the theory under 13B and restitution is simply based on 2 former cases, Porter and and Mitchell, both of which held that a grant of injunctive authority carried with it the historic power of equity. And if you go back to the, as you all know, Article 3 empowers federal courts to engage in law and equity. The first Judiciary Act of 1789 empowered district courts to order equitable remedies. Up until 1938, there were separate rules for equity cases. And so the history of equity is that that Congress's conferral of injunctive power carries with it the equitable remedies that historically have been available in the United States. And those include, as Tim was correct about this, the power for restitution, the power to appoint receivers, and so forth. The other thing about Section 13B that's often overlooked is that Congress wanted to encourage the FTC to be more ambitious, to engage in more active enforcement. But for Section 13B, the rate limiting process at the commission is you have to go through a single ALJ, and ALJ trials can take a long time. When I was at the Bureau, we had a case against Palm Wonderful. The trial before the ALJ took 3 months, 3 months of ALJ time, during which we wouldn't have been able to bring, the several dozen other cases that we were able to bring at the time. So Section 13B has done well. Now, court heard argument in AMG. I'm too old to think that I have any insight as to where the court is going to come out on this case. My own view is the right thing for Congress to do is to resolve this issue prior to the Supreme Court ruling. And here's one reason why. During the argument, the lawyer for AMG, very able guy, was asked a question that I'm sure he did not want to be asked, which was, so suppose, counsel, you win this case. What is going to happen with the $500 million your client, cheated consumers out of? And because he was a good lawyer and was an honest guy, he said, well, the government's going to have to pay us back. That's not an answer that the Supreme Court was going to be happy to hear, because what it suggests is that there are lots of judgments that have been paid to the FTC, lots of judgments in the last year or two. Are there going to be claims by companies who've paid those redress orders that now somehow or another the government's going to have to return that money? That was the argument AMG made to the Supreme Court. I don't think the court is going to be happy with that argument. So my own view is Congress should straighten this out. Congress should set rules and clarify where it stands. To the extent Congress has amended Section 13B since 1973, Congress was very much in favor of ensuring that the commission had the tools it needed. So to the extent there is congressional evidence of where Congress stands on Section 13B, the 1993 amendments are pretty strong, but Congress has always approved the FTC's work in this area. It was the right thing to do. Give Tim a lot of credit for fashioning this. I'm sure he'll have other views when he gets a moment to talk. But the house that Tim built has been very, has been rugged and has time tested. And I can't imagine the Congress, put aside the Supreme Court, Congress thinking it's all right for people to scam others, to take away lots of money, in the AMG case, about $500 million, and that's okay. So I think Congress should straighten this out. And I'm sure Tim has some good ideas about how we should move forward. So I will turn things over to Tim. Thank you.
All right. Thank you, David. No, Tim, it's all your fault. So go ahead and defend it.
Well, and I thank David for his kind words, and I thank my colleagues at the Scalia School for putting this on. Had David still been at the commission, I think the commission would have made more sensible arguments along the line that he's talking about. let me go back further in history, but let me start because a lot of what I'm going to say is what Justice Breyer said. And so let me say a few words about Justice Breyer. I first met him in 1975 when he was Professor Breyer, and I was very young working at the FTC. He had taken leave of absence to work for Senator Kennedy on the Judiciary Committee, and he was a law and economics guy, just Professor Breyer, and he convinced Ted Kennedy to become an advocate of airline deregulation, and that's what the FTC chairman Lou Engman was testifying on that issue. And indeed, Professor Breyer's fame on that issue and in law and economics in general, in December 1980, there was a lame duck session of Congress. He had been nominated to be on the First Circuit. And at a meeting, I was working on the FTC transition, and the Reagan transition was fine. I kind of don't know if you can imagine this happening today with the Congress, which was about to become Republican, confirming this Democrat as a circuit court judge. My soon-to-be FTC chairman and my boss on the transition, Jim Miller, spoke. Jim was an expert on airline deregulation, spoke very kindly of Professor Breyer's nomination. Indeed, when Judge Breyer was nominated for the Supreme Court, Ralph Nader and Lloyd Constantine opposed him because his views were too sensible, my word, not theirs, on antitrust. And where Justice Breyer started is where I want to start, which is in 1914, and with another justice, Justice Brandeis, and his vision of the Federal Trade Commission, which was to provide guidance to the business community, not to give money, because the FTC was that FTC, and much of the FTC's history, and Debbie alluded to this, was to provide guidance, was to provide rules in many cases in those days, virtually all cases where it wasn't obvious what the rules were. Well, you fast forward to the mid 70s, and there was a lot of movement for the FTC to be more aggressive. And there were, by that time, the line drawing was clear. There were some obvious problems. Congress was working on a unified set of FTC remedies, including the ability to get more injunctive powers and the ability to get money beyond civil penalties, which had been added in the Wheeler-Lee Amendment in 1938. So what happened was the easy part, the injunction part, was peeled off of this omnibus approach. And put on a bill that was going to pass, a pipeline bill. And so 13B passed. But if, and this is the position the commission took before the Supreme Court, if it was always essentially true that you could get monetary relief under 13B, the Congress then proceeded to do something bizarre, which was they spent a lot of time drafting a complicated procedure which became enacted as Section 19. They also drafted monetary relief under rulemaking procedures. But they spent a lot of time doing something that would have made no sense under the current commission's view. And that was enacting Section 19 to lay out a provision that for conduct that was dishonest or fraudulent, you could get monetary relief. Well, you fast forward to 1981. We come into the FTC. David discussed this, and I'll only add a few things. The FTC was, of the 70s, regarded its job to be the second most powerful legislature in Washington and to write rules to transform industries. We thought that was wrong. We thought, as did the ABA Commission, the first Patrick Commission, where Bob Pitofsky, David's and my good friend of Debbie and many people on this panel, where Bob, who was the guy who wrote it, said that one of the things the FTC ought to do was fraud. We sat down to experiment on ways to get fraud. We actually thought of 205, the penalty provision, which we're going to hear from in a minute. And we launched this experiment. But the experiment recognized that Section 19, we had to deal with Section 19. The only way we could rationalize what we did was that Section 19 could not work against fraud cases. And in this recent article, we lay this out in some detail. The only way you can go after fraudsters is to put them in jail or to take their money away. The only way you can take their money away with the FTC's powers is to tie the money up at the outset, and that's where the ex parte asset freeze came in. And the Section 19 procedures would not allow that for complex reasons because of the way they work. So then you fast forward to where another role of David's in the Obama administration, and when it wasn't just David, but in the Obama administration, they expanded this use of 13B, which had been blessed by 8 circuits, as David says. But those were all in the context of these fraud cases where clearly the strong argument that Section 19 would not work. But they in the Obama administration said we can expand 13B beyond fraud. Howard Beals and I, in the article that Bruce mentioned 8 years ago, warned that that view jeopardized the fraud program, and lo and behold, we have reached that day. The good news, and I think David, who's a very good lawyer, would have argued the case differently. The case before the court was a fraud case, and all they had to do was defend it as a fraud case and leave for another day this expansive view of theirs. But instead, in front of the court, there were 2 extreme positions. The FTC saying you can always get money, the other side saying you can never get money. Our position was under 13B, you can get money sometimes, but not always. Now, let me close with a word. That doesn't mean where with legitimate businesses, you could still use Section 19. And Section 19, people talk about its cumbersome powers. It has a lot more power against legitimate companies than you might think, because most of those legitimate companies will settle the case. They won't litigate. And the settlement, the difference between 13B and 19 is typing the different statutes. Now, some of them may want to litigate because it's more cumbersome, but there are real provisions against real sanctions outside of money against legitimate companies. And that leads me to my final point, which is the original purpose of the FTC in providing rules and the problems with always seeking money. There are a set of cases that we talk about that where it's bad policy to seek money. The best example is advertising substantiation, where you have a battle of experts. The FTC has long pushed for the provision of truthful information, and the FTC in a substantiation case, if you apply too high of substantiation standard, can actually chill useful information. And one thing we have learned during the pandemic is where Operation Warp Speed, the use of masks have blown through traditional FDA double-blind clinical elaborate testing. Masks, for example, could not, the science behind masks, well, the original, you should wear a mask. It was common sense, but there wasn't the kind of scientific testing that a lot of FDA types would have required. So if you always want money, there is a real problem in a substantiation sort of case. So I'm saying it's not just bad law, it's bad it's bad policy, and the FTC has put itself in a bad position where most observers, I agree with David, it's hard to read the tea leaves, but most observers think the FTC's always position will fail, and I hope that our middle ground has some chance of prevailing. So thank you for having me.
All right, thanks, Tim. All right, and our final panelist is Sam Levine. Sam.
Thanks, Bruce, and it's great to be here. And I'm at the FTC currently, so I'll start with the standard disclaimer that I'm only speaking for myself. I'm not speaking for the commission or any commissioner. So I thought the other panelists did a great overview of sort of the legal issues around AMG and 13B. What I want to argue is that regardless of what happens with 13B, the FTC really needs to rethink its remedial approach. I think if you look at our track record in recent years on some of the biggest problems facing consumers, there's a real question about whether we need to restore our credibility. If you look at our, I'm thinking in particular about the FTC's almost complete inaction in the years leading up to the financial crisis, even though the largest and worst subprime lenders were under FTC jurisdiction. I'm thinking about the FTC's complete inaction in the face of the student debt crisis, which accelerated in the early 2000s when service members were returning home from Iraq and Afghanistan and were being targeted by predatory for-profit schools. The FTC brought no cases until 2016. And I'm thinking more recently about big tech. You know, we all know about the Cambridge Analytica scandal. Facebook wasn't only under FTC jurisdiction at the time, Facebook was under FTC order. We had a monitor installed to track Facebook's privacy practices, and yet those abuses that were revealed around Cambridge Analytica were exposed by the press, not by the FTC. So, you know, I think there's this view that if Congress can just fix 13B, or if the Supreme Court can confirm our authority under 13B, as I very much hope the Supreme Court does, and David filed an excellent brief, and I think, I take exception a little bit to what Tim, I have a lot of respect for Tim. I think the FTC filed an excellent brief. I certainly hope we prevail. But there's this view that if we can just get 13B fixed, we can return to business as usual and that everything will be fine. And there are a lot of people, especially I think industry, very invested in a return to the status quo. And I think that would be a mistake. Because for all of the advantages 13B confers, and it's a critical tool that confers a lot of advantages, I think 13B has some pretty big weaknesses. And I think the biggest weakness of all is, you know, Debbie earlier talked about deterrence. The Supreme Court's made pretty clear that equitable relief is not supposed to be deterring. And in fact, under Section 13B, all we can recover is equitable relief. So what does that mean in practice? If a company, through unfair and deceptive practices, steals $100 from consumers, the most the FTC can recover is $100. Now, you have some law and econ people on this panel, I'm sure in the audience too. I think anyone would tell you that when the worst consequence you can face for stealing $100 is paying $100, and that's only if you're caught, that is not much of a deterrence. And I think this is especially a problem in the digital economy, where it's sometimes hard to calculate unjust gains or consumer harm. If you look at most of the FTC's privacy and data security cases, we don't recover any money at all. And then we wonder why these data protection abuses recur, even by companies under order. So I think it's clear that if we're going to restore the FTC's credibility and equip us to be an effective 21st century regulator, we need to keep 13B, but we also need to diversify our toolkit. And in particular, I think we need to identify ways to seek civil penalties. Now, I think certainly everyone on the panel, I think probably most of the audience knows the difference between civil penalties and equitable relief, but just to sort of explain it briefly, civil penalties are not capped at harm. The FTC Act says if you violate a rule or under other circumstances, which I'll get into, you can face civil penalties of up to $43,000 per violation. Of course, in most cases, we recover far less. But what's clear, and what courts have made clear when they've looked at this, is that civil penalties not only aren't capped at harm, they should not be capped at harm. They are designed to deter. They should be a multiplier of harm. And one of the interesting, underappreciated things that happened over the last few years under Chairman Simons is that I really think the harm-based approach to civil penalties is dead, at least for now. Chairman Simons issued a statement in Hyperbeard saying civil penalties should not be capped at harm for all the reasons, I'll let him speak for himself, but for all the reasons I think that I'm laying out here, that you really, if you want to deter, you need to recover more than what a company earned illegally. Okay, so if we want to get civil penalties, there are a number of paths the FTC can take to do that. And Commissioner Chopra has laid those out. I'm going to talk about 3 of them. The first is the Penalty Offense Authority under Section 5M1B. The second is partnering with other enforcers, particularly states, but also the CFPB and others potentially. And the third is a restatement rulemaking, and I'll explain what that means. So I'll start with the Penalty Offense Authority, which Tim mentioned under Section 5M1B. It was also known as Section 205, because that's where it was in the Mag-Moss Act. The Penalty Offense Authority basically says that if the commission condemns a practice as unfair or deceptive in a litigated order, specifically a non-consent order, and then another party engages in that same practice with knowledge, actual knowledge, that it had been condemned by the FTC, then the FTC can seek civil penalties against that party. Now in the late 1970s, and Tim can weigh in if I'm getting any of this wrong, but I've looked at the records, and in the late 1970s, the FTC used the Penalty Offense Authority quite broadly. We sent it to over 2,000 firms in a host of industries, major American industries. And Commissioner Patricia Bailey, who was a Republican, industry was trying to get it repealed, and she gave a speech where she said, this is an extremely effective and efficient way to enforce the law. But in the 1980s, as we've heard, the commission really shifted its focus away from market-wide problems and toward shutting down scams. And for that purpose, Section 13, Tim and others made a determination Section 13B made more sense. And in the years since then, the Penalty Offense Authority has been used extremely seldom. The last time it was used by the FTC was more than a decade ago. So Commissioner Chopra and I put out a paper in October. It's on SSRN and it's forthcoming in the University of Pennsylvania Law Review that argues that the commission should resurrect the Penalty Offense Authority. And we've identified a number of key areas of FTC jurisdiction and key areas of real consumer harm and market distortion, where the FTC can act almost immediately to trigger civil penalty liability for a broad swath of really harmful conduct, including fraud by for-profit colleges, online misinformation in the form of fake reviews and other forms of misinformation, business opportunities, both by MLMs and also gig economy business opportunities, and also digital privacy and more. We really think the FTC should get going on resurrecting this authority so that we can change the cost-benefit analysis around breaking the law. The second change that Commissioner Chopra has pushed for at the FTC is moving away from the go-it-alone strategy in major cases and working with other UDAP enforcers. The fact is we're not the only UDAP enforcer in this country. Almost every state has some kind of mini FTC Act or other consumer protection statute, and many of them can get civil penalties for violations. By partnering with these states, we can actually deliver better results for the market by recovering civil penalties, even if the commission doesn't have authority on its own. Now, of course, those penalties would go to the states and not the Treasury, but I don't think that's what matters. I think what matters is that we actually have orders that effectuate general deterrence, and that's something we can do by working with states. And this is certainly not a wild idea. If you look at our fraud program, which again, Tim was an architect of, we partner with states all the time. And even on major antitrust cases over the last year, we've partnered with a number of states. So we know how to do this, but especially in the digital privacy space and other areas where we traditionally go it alone, there's a lot that can be gained by working with other enforcers. Both we bring a lot of expertise to the table and a lot of experience, And other enforcers bring their own expertise as well as stronger remedial authority. And if that means sharing credit, I think most people at the FTC would think that's totally fine if we can deliver better outcomes for the market. So the third idea that Commissioner Chopra has laid out for how we can diversify our toolkit is restatement rulemaking. Now, FTC rules carry a big advantage in terms of our remedial authorities. When a company violates an FTC rule, we can seek civil penalties under 5M. We can also go directly to federal court to seek redress, actual damages, and other relief under Section 19. And of course, we can also bring Section 13B actions, as we often do. So rules have huge advantages for the FTC. Again, telemarketing sales rule, something I think Tim was very involved in, has been highly successful in recovering money for consumers who've been the victims of fraud. But rulemaking, I realize, is a bit of a dirty word at the FTC because of two myths. The first myth is that FTC MAGMOS rulemaking, which is the procedure we generally have to follow, takes a decade and is impossible to do. The second myth is that FTC rules have to be burdensome, complex, take a decade. These are both myths. If you actually look at our MAGMOS procedures under Section 18, a lot of the procedural requirements under MAGMOS, the FTC has imposed itself, and we can change. And in fact, a lot of our current rules are MAGMOS, and when we modify them, we can take advantage of a provision under that statute that allows us to pursue alternative procedures. And Chair Slaughter has talked about this very eloquently. The other myth about FTC rules is that they have to be massive and complex and burdensome. Not true. I would take as an example the current rulemaking the FTC is undertaking around Made in USA fraud. Now, this is an APA rule. All the rule says is that if you claim your product is made in the United States, it has to be made in the United States, or you're going to face penalties. Now, this imposes no burden on market participants. This has already been the law for decades. All it means is that if you're caught lying about where your product is made, the FTC isn't going to be powerless to hold you accountable, that we can seek actual relief for consumers. So what Commissioner Chopra has argued is that we should use that as a template for a restatement rulemaking that simply restates existing law. And one example he's laid out is an imposter rule that simply says it is a deceptive practice under the FTC Act to impersonate the government. You'd be surprised how many of our cases involve, not only against fraudsters, but against legitimate companies, involve impersonating or claiming endorsement by the government. Just by issuing a rule on imposter fraud, no burden on honest businesses, much stronger relief for consumers and honest competitors. The final thing I'll say, because I know I'm going over, is that I know there are a lot of people around the FTC who don't want to see the FTC move in this direction, who want to see the FTC return to the status quo. The ABA antitrust section put out a transition memo for President Biden a couple of weeks ago that actually said Congress should further narrow 13B. They said that the penalty offense authority should not be used broadly and could be overly punitive. And they even said that no money orders, that the FTC should continue to rely on them. And they used as an example when Uber misled its drivers about how much they were to earn. The report suggested that we should not have gotten money in that case. I think that is the complete wrong direction for the FTC. I think if anything, we need to be moving toward more rigorous analysis of whether our cases are actually deterring bad conduct, more proactive targeting of market-wide harms instead of chasing scams, and moving away from no money orders, which even Bob Pitofsky in the 70s said were scandalously weak. And that's his quote. I think we need to be moving away from those orders. And I'm confident that over the next couple of years, we are going to be moving in a new direction for the FTC, and we are going to restore our credibility as a vigorous 21st century regulator. Thanks again.
All right. So you guys were great. You, as the moderator, all I care about is that everybody ends on time. And So I was going to give the panelists, except Sam, who went over, but actually you have a few minutes. 4 minutes, up to 4 minutes, if you want to react to anything anybody has said. I'll take a minute to defend law and economics to Sam, but I'll do that at the end. So why don't we go in the reverse order and start with Tim.
Okay, well, Sam's paper with Chopra but I'll come to 5M1B in a second. But it needs to be read because it's a thorough defense of the 70s and a critique of what we did in the 80s. I'm sure they didn't know it. They were channeling Mike Perchuk in saying, "Why are you doing these silly fraud cases? The FTC should do more important things." Although they don't give Bob Patofsky the credit or the criticism for one of the articles on which they rely throws Bob in with Howard Beals and myself and Jim Miller as the villains of the demise of the FTC. In terms of 5M1B, we did a lot of work on 5M1B. Unfortunately, one of their main premises about how to use some of the statutes the FTC has been rejected in the courts. One of the synopses that they talk about, which laudably, which was one that we used when I was director of the Bureau of Consumer Protection, that approach was rejected in the Eighth Circuit. The commission tried to fix it and couldn't figure out a way to fix it. This is something Howard and I discuss in our monograph on unfairness in the FTC. Another problem is the FTC litigated cases do not provide the kind of specificity that you can use to draft synopses. And it was the career staff who rejected the approach. If you want to use the approach, you're going to have to engage in a determined litigated effort and write different kinds of opinions. The rulemaking approach, however, I think does have some real possibilities in the fraud area. But it has to be done with specificity again. Finally, in terms of competition and repeal, what Debbie was talking about and Maureen were talking about was something we did unanimously when I was chairman. And one of the main problems is it was repealed and nothing was put in its place. This was another big fight that we had in the early 80s. The commissioners wanted discretion, and we wanted to rein in the discretion. And why should the FTC be in competition to get money with the class action lawyers in cases where the class action lawyers are really following on to good government cases? Now, I agree that there are a lot of problematic cases that the class action lawyers pursue, but if they're following on to a government case and getting money, that strikes me as a useful division of labor. And I assume I'm about occupied my 4 minutes, so I'll stop.
I think we'll go next to David.
Point about Section 19. You know, I don't want to quarrel with the history that Tim lays out. I think his version of it is completely accurate. I do think that Section 19 has a different use and a different purpose than Section 13. For one thing, it authorizes the commission to get damages, which is not an equitable remedy. It's a legal remedy. And that very much differentiates it from Section 13, because all Section 13 does, and Sam made this point probably much more powerfully than I did, was to restore consumers to the status quo ante. And is that a deterrence? Yup, but is it as strong a deterrence as the threat of damages? Certainly not. The other power of Section 19 was that it gave the agency a real hook in rule violations, because that's part of what it covers. And these days, at least through 2012 or so, whenever we brought a rule violation case, we brought it under Section 19 as well. So, I do think they serve somewhat different purposes. And the fact that Rule 19, was enacted just a year and a half after Section 13, I don't think really cast any doubt on Congress's intent when it passed Section 13. Once it conferred injunctive relief, the expectation was that equitable authority of all stripes would be available, because that's the way things worked back in 1973. And and there was really no challenge to that, even though those questions were heavily litigated in the circuits. Let me say one thing about penalty offense authority. My view is much closer to Tim's than it is to Sam's. I do think it is a useful tool, but it requires, it really requires cookie cutter cases where an order in one case, a litigated order in one case, can actually sort of fit very neatly into whatever construct it is that the FTC is trying to do. We had a bunch of cases when I was at the FTC against people who were selling bamboo fabrics, which there is actually no such thing as bamboo fabrics. And we used, my recollection is we used the synopses in that case. But I don't think we were able to use it anywhere else. It's a very powerful tool, but I think Tim's right. It requires foresight. That is, you want to litigate the right case that can then sort of serve as the cookie cutter. And then you got to be very careful about whether the courts are going to uphold what constitutes actual notice, because actual notice is a term of art that requires a very high degree of scienter. So I'm sure I've used more than my 4 minutes. So thank you.
Okay, so Seth, we apologize for going through the intricacies and the minutia of the very complex FTC statute, but do you have any comments?
Well, the minutiae and intricacies of the FTC statutes, particularly Section 5 and Section 19, were really the underpinning for the Seventh Circuit and Third Circuit rulings, and adverse to the FTC's professed broad authority to seek disgorgement under Section 13. I 100% agree with David about one and perhaps only one thing that he said, but it's an important thing, which is that Congress needs to step in here and act. And I think there is some reason to think that the Biden administration will agree and work with the current Democratic majority in Congress to get some clarity here. One of the reasons I think it's quite important to act is, unlike some of the other panelists, I do think I could always be wrong, but I think it's reasonably clear from the oral argument in the AMG case that the maximalist position advocated, as Tim explained, advocated by the FTC in AMG and in Credit Bureau and in the AbbVie case is unlikely to win. There was I didn't listen to the oral argument on the day that it took place, but I've obviously, like everybody else here, has read the transcript. The first thing that I saw was a piece that Ron Mann at Columbia published the day after the oral argument. And I'll just quote you because I think it's so wonderful. His bottom line argument, which is his very first paragraph, he says, if you're arguing on behalf of a federal regulatory agency's authority to protect consumers from businesses, and Justice Stephen Breyer sets his face against you, then chances are your day is not going well. But that is what happened Wednesday morning when Joel Marcus appeared on behalf of the FTC in AMG Capital Management versus the Federal Trade Commission. And Justice, I think it's worth looking at what Justice Breyer's point was when he was examining the FTC's lawyers. He said, and I'm quoting now from the transcript, history matters. I think Justice Brandeis, when he was faced with a business community that was very suspicious of the FTC's power and thought it would be abused, and a progressive community that thought it's absolutely necessary to bring bad business practices under control, so they compromised. The compromise was, you've got to do what the FTC says, but before it tells you to do something, it will engage in an administrative process and find that what you're doing now is wrong. It will be a cease and desist order, later expanded under Moss Magnuson to include violations of a rule. So Section 5, cease and desist order, violation of a rule, damage of some kind. 19, the same thing. And now we have right in the middle, 13, no protection like that whatsoever. Don't worry, says the FTC, we will only use it in exceptional cases. I'm still quoting Justice Breyer's question. In 2012, they repeal that. And now 10 years later, after this has been in effect for a few years, I read that 100 cases under this provision are in the court, compared with 10 or 20 under the regular cases. And he then goes on, if you can believe it, for another page and a half of the transcript in formulating his question. But I think the point here is clear, which is that in enacting the Commission's original authorities under Section 5, the Congress was attempting to reflect a bargain between the business community and the progressives that very much understood that the Commission would proceed through administrative action first and then seek enforcement penalties for violations of whatever the administrative process produced. And that Section 13, which was enacted long after that, and at the same time that the Commission's authorities were expanded under Section 5 and in Section 19, seems quite inconsistent with that compromise. I have not actually seen in any of this current litigation the analysis that Tim laid out, which is that when you're talking about fraud cases, the Section 19 authorities just don't work. They don't make sense because they are so specific and so, and I would say, non-systemic. And maybe that is an area in which one can craft a role for restitution, if not disgorgement, under Section 13. As Tim pointed out, that argument was not even suggested at any point by the FTC in the current round of litigation. And it certainly wouldn't have justified the Commission seeking disgorgement in the AbbVie case, because AbbVie has nothing whatsoever to do with any suggestions of fraud, but rather an allegation of misuse of market power. And so I really do think that however the Supreme Court rules, it's actually quite important for Congress to step in and tell both the FTC and the regulated public what authorities the FTC has outside of its administrative remedies or judicial remedies that follow from administrative action to go into court directly. And I for one would very much welcome that.
All right, Debbie. So maybe I could pose a question. You could always refuse to answer it, but to make it a little easier, since you grew up on the competition side, there is a proposal to fix the FTC's civil penalties problem, but from Senator Klobuchar, and I was wondering if you had a chance to go through that and look at. I mean, it's got a pretty broad authority to get civil penalties in antitrust cases, and it contemplates some kind of sentencing commission-like process to figure out what they are. And just as a process, do you think that maybe on the competition side, if it passes, does that do the trick? Does it go overboard, or any thoughts on that?
I mean, I think this discussion has really shown that there's a difference between the consumer protection side and the competition side. Sam, a couple of times, talked about being an effective regulator. I think if you polled the Bureau of Competition lawyers and asked them whether they thought there were regulators or law enforcement authorities where that would come out, they don't think of themselves as regulators. And I think a lot of that is because, much of what they do is merger work, that it's all so fact specific that there are very few times that the agency is ever doing something on the competition side that is per se. And I think another reason, I hear Seth talk about, is it really extraordinary use? Well, on the competition side, it is pretty extraordinary. It has only been used, a dozen times or so, maybe a few more times than that, but very rarely. And I think there's good reason for that. I think, as folks have been saying, there can be follow-on lawsuits. And the question is, does it make sense for the commission to be, doing the monetary part of it, which is only going to basically prolong a lot of these cases because people are going to fight more if it's not just a cease and desist. You're going to risk that they don't make the law in the same way. You see, and there's almost a dichotomy even within that, where the anti-competitive practices group almost always uses Part 3 and has had case after case go up to the Supreme Court and end up with very favorable results, and that those decisions can be deterrent, right? And they also help shape the law versus the healthcare shop, who I think went to federal court and started trying to get disgorgement in part because they felt like we're just not getting heard on the reverse patent settlement cases. And I know there was a time when some at the commission were thinking, should we have a rulemaking to make reverse patent settlements illegal? And there was, I think some preliminary discussion of that, but it never went very far. And I think it's because there's some real pros and cons to using the monetary relief. So, is it always good for an agency to have tools in its arsenal? Who has ever been at an agency isn't going to say, sure, more tools is great. The question is it always right to use them? And I think that is very much a case-by-case approach. And what works in terms of frauds and boiler rooms and that sort of thing may not be the right thing for, an exclusive dealing arrangement, which, may or may not have anti-competitive effects and may have different levels of anti-competitive effects. There is in the antitrust world too a risk of over-deterrence. And if you tell people, you are going to get significant fines or disgorgement every time you do, an exclusive dealing arrangement that we think is unlawful, when there's, some guidelines as to when the government's going to really be concerned, but also a lot of uncertainty. I think it's going to put a lot of pressure on the agency to have a lot more certainty in what it's saying, a lot more pressure to give guidance. They're going to spend a lot more time figuring out how to administer where the money goes. That's not always easy. These things have pros and cons, even if you have the tools to use them, is what I'd say.
All right, Sam wants his 2 minutes.
Sure, I'll be quick. I'll just say that I fully appreciate some of the challenges around the penalty offense authority, and I appreciate the problems that Tim identified in the 1980s and since. And I think, as David and others have said, this really is the house that Tim built, and I think I am also in awe of his brilliance in a lot of ways. But I don't think we should overstate either sort of the difficulty of this. It's not a panacea, it's not a walk in the park. But if you look at a lot of the frauds the FTC deals with, they're evergreen. And we identified in the article a lot of very clear orders of cases with very clear applicability. Tim mentioned an Eighth Circuit decision. I think he meant Hopkins Dodge, which is about the commission's finding being insufficiently clear and a TILA violation. We did not argue that we should use penalty offense authority for TILA. I think that's settled law. I know the commission made that decision. But what we did argue is that there are certain types of law breaking that's really clear. I'll give you an example. In Cliffdale Associates in 1983, and that's where the deception policy statement is appended. The FTC found it's deceptive for someone to endorse a product without disclosing their material connection to the endorser. That's the exact same theory. In fact, that's literally how our allegations read when we go after fake reviews today. Same with for-profit schools. We sued DeVry in 1980 for misstating its job placement rate. We sued DeVry in 2016 for misstating its job placement rate. There's a lot the FTC does that's very complex, but there's a lot that's pretty simple and consistent. And the last thing I'll say just about class actions and no money orders, the consumers I've dealt with who've been the victims of these practices, especially the victims of fraud by major for-profit colleges, it's not easy to just join a class action. Most of them have signed class action waivers, and very few of them get even a nickel, even though they were defrauded of tens of thousands of dollars. And I don't think we can rely on class action lawyers as a justification to abdicate our own responsibility to use the tools Congress gave us to return funds to consumers who have been defrauded.
Yeah, I just wanted to respond to Seth's point about Justice Breyer. I mean, he is an expert on administrative law, and the question that he asked after his long introduction, which is not atypical for Justice Breyer, was whether the FTC was bringing cases under Section 13 that should be brought before the Commission to articulate standards to provide guidance for the industry. Now, part of the problem with the arguments these days, and Breyer has been the chief sort of critic of them, is it doesn't really allow for the kind of back and forth that you'd see in a normal oral argument. So the FTC lawyer tried to make clear that the FTC does not bring cases under Section 13B unless there's substantial Commission precedent on the issue. I don't think the FTC would disagree, as Justice Breyer noted, that its principal mission is to police the marketplace by giving businesses clear guidance about what constitutes a deceptive or unfair business practice. No one, I don't think, would dispute that in the absence of clear guidance, the FTC should not proceed in an enforcement action. Due process requires notice, but also that is the DNA of the FTC. On the other hand, Section 13 does authorize the Commission to go straight to court when the Commission has already established guidance. And that was the point of Section 13, which was, and now I'm quoting the legislative history, to ensure Commission resources will be better utilized and cases can be disposed of more efficiently, close quote, if the agency can take the mind run of cases directly to court. So I'm not, if I were Seth, I wouldn't be certain that that Justice Breyer was going to rule against the FTC. I think he's worried about this, and I think it's a fair point. But I don't think that necessarily means Justice Breyer is going to vote for AMG in this case. But also, I'm not going to bet with you about the outcome.
All right, so we have 10 minutes. There's actually a question in the queue, and I guess this is the law review put together a great panel. I guess it should have worked on their title. It should have been the future of FTC remedies under Section 13B or something like that, but it just said future of remedies. So somebody wanted to know about whether or not the Biden administration is going to use behavioral remedies in merger cases, and also whether or not they're going to look at pipeline cases, I guess, killer acquisitions and things like that. So I guess that would mostly be to you, Debbie.
Sure. I do believe that they will use conduct remedies in appropriate cases because I think they can be useful. And I think that there are situations where the efficiencies of a merger, particularly in a vertical merger, I think is where you're likely to see them, where there's recognized efficiencies that a remedy other than completely blocking the transaction or requiring a divestiture that basically undoes the vertical integration would be the only alternative, and where there are reasons to believe that a conduct remedy would be workable. So I give as an example of a case that I worked on years ago, where I think if the exact same pattern came up, the conduct remedy would happen. Pepsi decided to buy its bottlers. And the bottlers also bottled Dr. Pepper. And there was really no question in anybody's mind about whether Pepsi would simply, stop supplying Dr. Pepper. It was hugely for them to do so. They had a great agreement, and Dr. Pepper and Pepsi had worked out an agreement where that was going to continue. But the one concern, and the documents, internal Pepsi documents, were so clear on the benefits of this transaction. I've never seen a business so clearly write out, we are going to eliminate double margin, but put it in business words, not lawyer words. So, and there were economic analyses done, all sorts of ways that demonstrated that. The one and only concern that the commission had was the possibility that Pepsi at the parent concentrate level could learn through the bottler about some innovation that was being done. The one they always used with us was they might do a can in the shape of a football right before the Super Bowl. And if the bottler knew that because they had to do a new can or they had to do a new design, could they tell the parent, who would then thwart it by basically making fun of it or doing a counter ad or beating them to the punch. And basically they said, we're going to put a firewall in place. And Dr. Pepper, who's really the only agreed customer here, right? This isn't a situation where you have a billion, said, yeah, we're good with that. We've got all kinds of remedies in our agreement. And if there's, an FTC order on top of it, along with, penalty provisions and a monitor overseeing it, we think this is a good situation for everybody. And so there was a conduct remedy put in place. The commission took the position that it should last for something like 20 years rather than the usual merger remedy of 10 years. So I believe it is still in effect. But the point being that the folks involved everyone was quite comfortable with it. And I think if that situation came up again, I think that the commission would, have to think very hard about it. And even, recently there have been a couple of conduct remedies, so I think they're still going to do that on occasion. I think they're going to look at it very carefully, and they're not going to want ones that are overly complicated. That's a very simple consent order. I think it's going to be a different situation if you basically have to have numerous customers who could be foreclosed and you're essentially spelling out what otherwise would be an agreement between the parties in a consent order. That's a different sort of situation. On the question of killer acquisitions, I think that's a whole different panel that this group could spend time on. But I think the commission has been looking at nascent acquisitions. You call them what you want, potential competition and the like, for all of the 30 years that I have been practicing law, and I don't think that will change. And they're very fact specific, and whether you call them nascent acquisitions or potential competition or killer acquisitions, I think folks are going to look at the facts, and if those cases look to get rid of, if a transaction issue looks to get rid of important competition, absolutely the agencies are going to look at that.
All right, so I get my 2 minutes with Sam. I actually always enjoyed going into Commissioner Chopra's office. It was always the most fun and engaging, and it was challenging. But so Rod Rosenstein at DOJ had a no piling on policy, and I think it's completely sensible that when the FTC is looking at some type of law enforcement action and remedies, even when their remedies are no money penalty, you think about what other, not just class actions, but the states, the DOJ, and you mentioned data security, the Equifax. I don't remember what our side of the money was. It was something embarrassingly small, but I mean, there were all kinds of other agencies that had authorities. CFPB doesn't have the same problem. And so if you think about the FTC's authority in and of itself, that's the wrong sort of perspective. And I think you sort of said, the FTC certainly doesn't have the adequate authority, but maybe overall somebody does. And so, Rod said, we have to sort of at least think about coordination, which is very hard to do between the agencies. But it's not just what the FTC gets, it's what everybody gets, and how do you coordinate that, especially when there's follow-on private litigation. The other thing is that, and this is a fight that I've been having throughout my whole career in government. I worked at the U.S. Sentencing Commission. Steve Breyer was one of the commissioners. It was a really neat place, but it was a really scary place because economists ended up with their stuff on the street almost every week. They just threw them out. And we always argued that harm-based penalties, and those are crimes, right? But harm-based penalties were the reason you want harm-based penalties is that for things that are properly crimes, right? Harm is greater than the gain, right? And so harm-based penalties are always greater than the gain. And then you have a multiplier, right? I mean, if you follow Becker. So, I disagreed with Chairman Simon saying that, we ought to end harm-based penalties. We ought to end harm-based penalties when there's a chance that detection and punishment is not, it's not with a probability 1. But I think as a principle, it's the most sane way to figure out what the penalties are, because you don't want arbitrary large penalties on businesses because it'll cause over deterrence.
So I agree you don't want arbitrary penalties. And I think when I was referring to harm-based penalties, I was referring to the notion, which I've certainly seen at the FTC, that civil penalties should essentially be capped at harm, when in fact, we have these two types of relief, equitable relief and civil penalties, where it's equitable relief that's supposed to be capped at harm. So part of it is just recognizing what our goals are and how we can be thoughtful and strategic in realizing those goals. In terms of what you said about piling on, I certainly understand where Rod Rosenstein was coming from there. I think if you look at cases the FTC has brought with states, we actually take a pretty reasonable view of this. If we take $1 million, let's say we want $1 million judgment, we're not going to say $1 million for the FTC and $1 million for some state. We look at the overall package and figure out whether it makes sense and figure out whether it's something we could prevail on in court. So I actually think the FTC knows how to coordinate with states and do it in a way that's both fair for businesses, but also delivers results for consumers. And I guess sort of the last thing I would just say to respond to some of what others have said, I agree that for novel theories of unfairness or deception, we should not be seeking crippling civil penalties. I think if any, another thing Commissioner Chopra has argued is that we should be using our administrative forum more, and I agree with what Tim said on this, to develop the law around unfairness, to develop the law around deception. Where we think that we need to step up deterrence is around conduct that's clearly illegal and that has been illegal for decades, and where there's really no ambiguity that companies are breaking the law.
All right. Well, I think we're just about out of time. I want to thank our distinguished panelists for the discussion today. It was great fun. And that concludes this session. Please remember to return at 4 p.m. Eastern for our next session, Antitrust and Collegiate Athletics for all you sports junkies. I'm sure it's going to be another interesting panel, even if you're not a sports junkie. Tomorrow, we will see the GAI Moot Court Invitational, final arguments judged by Judge Ginsburg, Tim Muris, and Ian Forrester. We'll look forward to hosting you for our next panel, and that's at 4 o'clock. All right, well, let's thank our panel and for the lively and great discussion.